President CA Pramod to escort our I request CA Pramod to welcome the gathering.
Good morning, participants, and a very warm welcome to this ITAT intense course. Very hardly we see members meeting in the morning for a session like this, and it's very glad we all are having so many of them come early to witness a very interesting session and then program. Now, when this program was designed by KSCAA, our intent was, should we train the youngsters who have not even seen ITAT? Should we train somebody who has gone to ITAT but upskill him to the next level? But we don't get participants of such sort. We always get it in a mixed bag. Now, this program, why we did this mentorship is because everybody's individual ability is very different. Everybody's ability to understand is different, and they were probably at a different level of professional journey. Some of them are at their age 28, 30. Some of them are at the late 40s. So doesn't matter. We said when the mentorship is given, it is always a very individual attention which is given to them. And that's how we wanted them to be trained and moved up. Karnataka State Chartered Accountant Association, which is a 66 years old organization, has been in the forefront conducting such programs. Now, the current year's theme, which is create and complement. This program probably fits exactly to this theme because this is something which we are trying to create a new journey for the professional members. And also it is complementing because a mentor is giving his best, his advice to the juniors so that they can also learn from it. So it couldn't have been more better. It couldn't have been more better than to suit the theme of create and complement. Now, as a part of KSCA, some of you are already very old members, some of you are new members. For those of you new members, I want to just reiterate that the programs by KSCA include not only of professional things, it also includes sports, cultures, it also has annual conference. Our annual conference of KSCA, which is the 35th annual conference, is scheduled on 17th and 18th of March 2023. We will be coming out with the brochure. Our sessions are there. Please look out for the space. Do register. Tell your friends. And the membership of KSC also is currently going for a revival. That is, whatever we are currently charging is getting into two in a very short time. So if you have any of your friends whom you feel has not registered for KSCA, has not become a member of KSCA, please do tell them that it is an organization where you can come, network, grow together. I don't want to waste much of time. We have a very expert and a renowned speaker here. I request Naveen Kariwal sir to take over the proceedings from here. The KSCA's one important leg is representation. The voice of chartered accountants are only heard by representation. And we have been very actively involved in giving the representations to government, both in terms of direct tax, GST, corporate law, even to the cooperative departments, which is the government of Karnataka. We have already filed around 5 to 6 representations in this term. If you have any issues, if you have any problems, if you have grievances, which you feel apt that we need to be represented as a profession, do pass it on. We are always there to hear you. We will pass it on as a representation. This is, I thought I'll brief before I hand it over to Naveen.
Morning, all the participants assembled here. I was just given a brief by the President as well as Deepak to address all the participants so that you will get molded to prepare yourself for this intense course. Now, first things first. When was the tribunal formed? What is ITAT? When was it formed? Tax was introduced in India in 1860. Very first ITAT came up in 1941 with 6 members at 3 places, 3 benches, Delhi, Mumbai, as well as Calcutta. 2 members, each 6 members. Mohammad Munir was the first president of ITAT. Now, without your knowledge, you have enrolled for this course, intense course. Almost after 2.5 decades, this course is being held in Karnataka, Bangalore, courtesy Karnataka State Chartered Accountants Association. After more than 25 years, my dear friends, this course is held, and you need to clap yourself, give a reception to yourself for having joined this course. At the end of this course, now, what is the purpose and intent and object of this course? Why have you joined? What is the end result? Why did you join? What is the end result? Wait for 2024, my dear friends, when the ITAT would become fully faceless. I am more interested in 255 subsection 7, subsection 8, subsection 6. When you go there, the government is telling up to 2024 I can issue some guidelines or notifications, etc. Thereafter, I will not issue any guidelines. It is on the way to become faceless. So as of now, you have the opportunity in another 2 years. Why 2024? Why they did not extend the date? For CIT appeals, it is 2022. They stopped at 2022. Why 2024 for ITAT? Probably Modi's term is ending then. And then when he comes back again, they are going to decide again. So probably at that time, faceless tribunal, you may not have an opportunity to, standing in life, blood and person and appear before the ITAT. Now it's very, very simple, the provisions, don't worry. What you have to understand is, this is the Bible. The Income Tax Act is the Bible. 246A to 251. 250 is about your CIT appeals. Thereafter 252 to 255 is about your ITAT. What is the difference between CIT appeals and ITAT? Point number 1, Form 35 for CIT appeals, Form 36 for ITAT. How many days, sir, for filing appeal? Today you have received the order, or today you have received the penalty order. Within 30 days from the date of receipt of assessment order or penalty order or any other order, please file an appeal. Time limit for filing first appeal before Honorable Faceless National Faceless Assessment Appeal Center is 30 days. For tribunal, it is 60 days. Then what happens? Then what is the appeal filing fee? What is the appeal filing fee, sir? It is based on assessed income. Up to 1 lakh rupees. CIT appeals, 250 rupees. In ITAT, up to 1 lakh rupees, it is rupees 500. Assessed income, it is always on assessed income. Appeal filing fee, it is not on returned income. The next slab, between 1 lakh to 2 lakhs. Here you please come, it is 250, 500 rupees in CIT appeals. Thereafter, it is 1000 rupees, above 2 lakhs. In ITAT, it is between same thing, same slabs, 0 to 1 lakh, 1 lakh to 2 lakhs, and then 2 lakhs and above, it would be 10,000, it would be up to a maximum of 10,000 rupees would be the ITAT appeal filing fees. Next, memorandum of appeal. What all have you to attach? With Form 35, you have to attach order of the assessment. If you are filing an appeal against the assessment order, in duplicate, please attach 2 copies of assessment order, original notice of demand under section 156, and the challan of appeal filing fees. Same thing is in tribunal. It will be in 3 sets. Always make a bunch of 3 sets. Assessment order, Form 36. Then what is Form 36A? Memorandum of cross objections. If example, the department prefers an appeal, then you guys have to fill up Form 36A. That is the cross objections. And that is also will be disposed of by the honorable tribunal as if it is an order. So what is the time limit for passing order? Assessment procedures means only time limits, time limits, time limits. CIT appeals 250 subsection 6 capital A. Time limit for passing CIT appeals order. The law itself is a funny law. It says wherever it is possible, the CIT appeals may pass an order within 1 year from the end of financial year in which appeal is filed. The same time limit is also applicable for your intimation under 143(1). Within 1 year from the end of financial year in which intimation, in which return is filed. Time limit for processing of intimation. Same time limit is for appeal, sir, but the law unfortunately uses the word may. Therefore, these fellows, they don't pass the order within 1 year. 250 subsection 6A is crystal clear. It says may. Whenever this fellow feels, he may pass an order within 1 year from the end of financial year in which appeal is filed. Similar time limits are given here. Now, what we need to do, what we are going to do in this course. My good friend Kapil is there from Delhi. Narendra Jain is there from Bangalore. Anu Shekhar is there from, Chennai. Vikram is there from our, again, Bangalore, advocate. I am telling you, all four are fantastic, speakers. And more so because of their knowledge. More so because of their experience in representation. Before going further, I would acknowledge the presence of T.N. Sridhar sir, who retired as Joint Commissioner of Income Tax, was instrumental in preparing at least 25 appraisal reports for search. One of the, he's also a member of Direct Tax Committee along with our Prashant GS here. Yes, sir? I think you are a member also. And he retired as a Joint Commissioner, and one of the officers with lot of inquisitiveness, one of the officers we found more knowledgeable while interacting, had a very good, knowledge of law. So anyway, moving further, sir, now, please take it seriously. You have been handed over. This course will be a life-changing, game-changing opportunity for you. You need not depend on anybody. See, when going on stage, when you go to the tribunal or when you, today CIT appeals anyway, it is faceless, you can ask for video conferencing, fine. That fellow is sitting miles, thousands of miles away in Ahmedabad, etc. I am sitting here, I am going on talking 10 minutes time or 20 minutes time he gives me. I will go on talking, happily sitting in the comfortable environment of my office. This at present is a different ball game altogether. You are going to stand in the tribunal in front of the judge, member, etc. and you are going to debate. Similar thing, podium will be there, you will keep your books and you will go on talking. Nothing to worry, sir. Final fact-finding authority is ITAT. If there is any substantial question of law, then only you can prefer an appeal before the Honorable High Court. So therefore, brush up your knowledge on the Act. When the order comes, anyway, you are filing. Now 246A, appeal you are going to file. How many sections are there, sir? 246A, appealable orders before the CIT appeals. Round about 26 orders are there. A, B, C, D, AA, etc., etc. Round about 26 orders are there. In between, there is a section for penalty orders also. I am not taken to that consideration. That may be another 12 sections. So 26 plus 12 minus 1, maybe 37, 26 plus 12 minus 1, maybe 37. But exactly 26 sections are there, which are appealable orders before the CIT appeals. When you come to tribunal, there are round about 7 sections, which are appealable orders before the ITAT. Just sitting with the present member, I will not name him. So after 2 o'clock, 3 o'clock, we just sat there. 1.5 hours, I just sat with him. We discussed over a cup of coffee. He showed me some orders. They opened the rack. He told, get me these orders. A chartered accountant appeared from Mangalore. He was just telling me, see, adjournment, adjournment, adjournment. From 2008, he told me this case is there. I am myself telling the CA, I am telling you, please don't take adjournment. I am going to give you next 2 days, 2 days, 2 days. Case is being adjourned from 8, disposed of into 2022. And it was a case about 41, and he gave him substantial relief. Say he would have got around 60 to 70% relief. And he told, unfortunately, what the member told, I am telling you, there is nothing to feel bad here. He told me, I am telling you, please talk, you please talk. I am helping you. You please talk. He is not able to talk. He is not able to convey at all. So this, my dear friend, this course will prepare you how to talk first. Many of you among are there. You are all brilliant. You know the law very well. But you cannot express yourself in words. This course will prepare you. When you go to the grind of this course, you will have confidence in yourself. You can stand on the stage, express yourself without fear in a very clinical fashion. Understand the law. Many of you, I am telling you, you are all much better than me in this audience. Much, much better. You know, have a thorough understanding of law. Unfortunately, you cannot express. That is what the member told me. He told me, I am trying to help him. Come out, sir. Tell me, sir. Tell me, sir. Karke. He is not able to talk. Somehow I helped him. He was a good member. He helped him. 60% he got relief. 2008 case disposed of in 2022. Anyway, that is a different story altogether. So I am telling you, you have to learn this. First, when you go and stand there, law you are going to prepare. You are all, having passed the chartered accountant's exam, nothing to worry about the law. You are all well versed with the law. Now go to the grind now. Take all the mentors seriously. Even the mentors, Mr. Deepak has told me, they are all fantastic people, I am telling you, with thorough knowledge. The mentor should become mental. Because of the questions you ask, don't leave them. Don't leave them. If you want to succeed in this course, make the mentors mental. Don't leave them. Go on asking questions. I saw the names you told me. They are all, I'm telling you, absolute gems. Because they have got knowledge, they have appeared before the tribunal. It is up to you how much you can extract. I was just talking to the president and I was telling him, what is this, sir? Charge of the course is not in proportion to the result they will be getting at the end of this course. So anyway, that is not our, rather goal. They were just discussing. But if you take it seriously, my dear friend, this is a life-changing, game-changing opportunity for you. It is not like any other course you are just going to come, sit, relax, chit-chat and go away. This is not the course. Highly intense course. You have to be dead serious. Anyway, appreciation of law is there. You know, you will understand the law also. But then practically when you appear, how to talk, how much to talk, where to stop, how much to talk, where should be the pause, where to breathe. You take the movie Kantara now. Take that movie, take the climax scene, come to this representation before ITAT. See the eye expressions. See the eye expressions of the actor. What is your eye expression in front of the member or judge? What are your expressions? By your expression itself, he will find out whether you know the law, whether this fellow is snobbish, whether this fellow has an ego. See, if we go there, I have the habit, of extending my hands left, right, up and down on the stage. So we are habituated. You cannot stand there and create a scene there and do a drama there. See the eye expressions, talk straight, look straight in the eye of the judge, and talk how much is required. You should know where to pause, how to talk, where to stop, where to raise the voice, where not to raise the voice, where to stop talking. Many times, then again the member was telling me, he argues too much, that fellow. I'm not going to name anybody. That fellow argues too much. I told it is allowed. He is not stopping at all. He is going on. One more person he told, because he didn't stop, I dismissed the case. If he had stopped, I would have allowed the case. See, these are all, after all, he is also the person on the other side is also a human being. Person on this side is also a human being. They have their own, moods, swings, etc. So be very careful. Before that, I am telling you, you have to go to the grind of the course. And please prepare well. And please, I am telling you again and again, take the help of mentors. Trouble them. As much as possible, learn from them. Don't think that, he is my junior or he is my senior, I passed out earlier or now I have come. No, that is not the way. Knowledge, there is no age for knowledge. There is absolutely no age for knowledge. I can learn as much from my article. I can learn. First year article I would have joined. I would have learned so much from it. It is not a one-way traffic. It should be open there. If I am able to take, then only it's possible. I was sitting with the CPC commissioner the other day. I gave him 25, CPC commissioner I was sitting other day, I gave him 25, issues which are appearing on the portal now. He was very happy. He told, sir, single issue we have not thought of. Single issue is telling what all you have told, single issue we have not thought of at all. Where is the question of, plugging the loophole? For example, I raised an issue, sir, now there is AOP. AOP means executor. When I go and add on the SSC, it says, legal representative. If I put legal representative, it is, only for the deceased. How can AOP have a legal representative? Thereby it will be taxed at MMR at maximum marginal rate. You put the word, enable the word executor. Where is the question of enabling the word executor there? Yes, sir, it is not there. Karke. You use this. Like this, we raised 20, 25 issues. So anyway, I think my time is up. I am standing between you and breakfast. So, again, at the end, I congratulate all of you. Get ready for this intense course. And I'm most thankful to my President, KSCA, Pramod Shiri and team for having invited me on this Saturday morning to address you all. Thank you very much.
We acknowledge the presence of two mentors with us, TNC Sridhar sir and Suma ma'am, who have joined us this morning.
KSCA for giving an opportunity to be a mentor. I've been associated with training since 1986. Anyway, past the total bit, I'm not going to much on that. The points which my friend has raised over here, very important aspect of my experience being before the tribunal and also before the High Court representing department. I was standing counsel for 3 years. Present is that. It matters how you present the matter. That's very important. In fact, I would like to share one example of one person stood before the tribunal. He was very tall, a very hefty figure. His voice was very loud. And when he stands, the members, even if they're sitting at a higher pedestal, they look puny. They feel puny. And this fellow talked loud. And they didn't want to stop something. They simply said, "Where is your tie?" Didn't ask anything. "Where is your tie?" "Oh, it's in the pocket." They put on the tie and then come. You put that fellow off immediately. He prepared everything, whole night he might have prepared. But because he was not dressed properly, probably overconfidence, and he forgot, at that point it came up. And members are two types. One is accountant member and one, this one, judicial member. From judiciary who comes in the sense, I'm talking about the people who have been judges and they are coming. I am not doubting about their knowledges. But some point of time they ask such question, we really wonder at what level I should start presenting before the member, before the person on the other side. Just to quote an example, a company had failed to deduct tax at source. The prosecution was launched, making the two directors as the co-accused in that. The lower court convicted the company, but acquitted the directors. So the department had to go to the High Court on two separate counts. One and levied a fine of 10,000 rupees. For enhancement of the fine and also against the acquittal of the directors. So when I went before the High Court for the notice stage, he said, "What is the point?" I told, "My lord, here is the company which has been convicted by the lower court and levied a fine of only 10,000 rupees. If the company would have come for compounding before the department, it should have paid 2.35 crores. So it is disproportionate. This is not having demonstrative effect." He said, "Then why didn't you go for compounding?" I didn't know whether I should laugh or I should cry. A High Court judge asking me that question. Then I had to tell him, "My lord, it is not my prerogative to go for compounding. It is for the assessor to go for compounding. If he does not want to feel the rigor of the prosecution and getting convicted, there is an alternate route available. He can come, he can pay the department and get absolved from this particular thing. But if he desires to go to the High Court, there he can get convicted." He said, "Then what is the punishments levied?" I said, "There is imprisonment. Company not being a natural person, obviously it can't be imprisoned. Only fine will be the thing. What is the fine prescribed under the law?" I said, "There is no prescription." Okay. Then what is wrong? 10,000? No, that is the way sometimes the court asks questions. You feel this one. So question is that you, as he rightly said, your eye contact with the member is very important to assess whether he knows the subject or not. Very often you think he knows the subject, that is your thinking, which may be right, which may not be right. Somebody asked me, "Why are you doing law?" I said, "I'm wearing a black coat so that others will think I know the law, but I am not responsible for their thinking." But the question is that when you make eye-to-eye contact with the member, very often it is not the matter that is presented, but it matters who presents the matter. Somebody look at his face, the immediately member pressure will go up. And some people will, whatever he says, they will say, "Yes, my lord. Yes, your honor. Yes, your honor." Addressing is very important. All those things are there. Of course, I am very thankful for giving that opportunity to be a mentor. I will do my best. This is my first time I am giving such an opportunity. I will try to do my best to see that whoever is assigned to me, they are benefited from my exposure in this income tax. Thank you.
No, before we proceed further for the breakfast, I thought it's important that we all are on the same page. We all understand the course in the way it has been organized. So I'll just give you a brief, broad outline of the course, and if there are any queries that you have in your minds, you're free to have them resolved here. So this course in all has 3 components. There is sessions, which is basically classroom sessions wherein theoretical knowledge is going to be imparted. Then there is mentorship, wherein you'll have hand-holding by domain experts on how to actually go through the appeal filing procedure. And then there is a moot court competition, right? So sessions in all, we have 4 sessions. So today we'll have our first session at 10:30, which is on legal provisions in a tax appeal, 254 ITAT rules and all of that. Followed by another virtual session today evening, 4 to 6. The Zoom invite will be shared on the WhatsApp group. So that's going to be on drafting skills in an ITAT appeal. So how do you actually fill in a Form 36? How do you draft a grounds of appeal? How do you prepare a synopsis? So drafting skills is what we'll be concentrating on in our today evening session. Thereafter, on 7th, we have a very important session, again 4 to 6 Saturday evening, by Advocate Kapil Goyal, again an online session, on representation skills in an appeal. So as was pointed out, how to structure your argument, how to pace your argument, right? How to prepare for your argument. So practical tips on how to go about with that. And then on 7th of Jan, again 4 to 6 Saturday evening, we have another online session on legal principles and jargons in tax appeal. We've heard this all, no? Natural justice, principles of natural justice, law of precedence, preponderance of human probabilities, telescoping, peak credits. Some of these jargons, very high funda sounding jargons with very important concept which normally scares off a young practitioner, a young reader, are going to be elaborated and discussed over there. Between all these sessions, we'll be starting off with our mentorship right from today. So we've already grouped you on the basis of area that you've chosen, your preferred. We have also formed WhatsApp groups. We'll be introducing you to your mentors today, post the evening session. We'll bring them also onto the WhatsApp group. Now this is the core or the most critical part of the course. So under the mentors, you will be supplied with live cases, you will be supplied with actual cases, and you will be handheld to yourself draft the grounds of appeal, fill in the Form 36, prepare the synopsis, prepare the case law compilation. All of it will be done by you, provided you have the time and effort, you're willing to put in that time and effort. So mentors are going to call you at their area, at their place, at their convenience, at the timings that they feel are, they are available for. So it is very important that you respect the time and the effort being put in by the mentors. So if a mentor is calling you 6:30 in the evening, you will have to be there by 6:30 in the evening. I would rather suggest you'll have to be there by 6:15 in the evening, not even 6:31, right? The case, the Form 36, that is your appeal memo, will have to be filed with KSC office before 31st of December, 5 o'clock. Any further submission to be filed will have to be done before 4th of Jan, again at KSC office. Cutoff time would be 5 o'clock. On 9th and 10th, we'll have a qualifier. So you will get to present your case on the 9th and 10th. And out of the 40 participants that we have, 10 will move on to the next round that will be held on 21st. So 21st is a finale which we are having at National Law School. So it's in the moot court premises of the National Law School. And that is going to be presided by the existing bench members of the ITAT. So we'll have Vice President Mr. Vasudevan, we have George sir, and we have Madam Padmavati, who will preside over the bench on the 21st. So your journey, which starts here today on 17th, will conclude on the 21st. And this next 1 month is going to be intense. So there's going to be a lot of traveling that you might have to do to meet your mentors. And see, and mentorship is something which is not going to happen in a day. It's not that I'll sit with him half a day, one Saturday, and finish it off. It'll happen in bits and pieces. So the mentor probably is going to call you on Monday or a Sunday. It could be a weekday or it could be a weekend. It's entirely to his convenience, and we'll have to respect that. So the first day probably you will only get to introduce yourself, build a channel with the mentor, get cases assigned. You'll have to go back home, read, come up with a first draft of your grounds, make multiple visits to the mentor's office to have those drafts improvised, and come up with a draft which is, in a fileable state, right? So this is going to be intense. This will require a lot of time and effort. And as sir pointed out, the result that you're going to get out of the course is going to be directly proportional to the time and effort that you put in. The greater the time and effort you put in, the greater the output that you're going to derive from the course. The mentors are all domain experts. They are experts in their field with enormous amount of experience and n number of years of experience in the domain of ITAT appeals. Now it's up to you. How much of it can you extract from those mentors, right? If there are any queries with regards to the program structure, I would be happy to address them now. That has already been done. In case we have missed out any of you, you can reach out to me in the breakfast break. So you are already into WhatsApp groups. If anybody is left out by any chance, you can always reach out to me during the break time. Before we break for the breakfast, I think it will be a good idea to have an introduction of each of you, a 30-40 seconds introduction of each of you, and you can also point out to which subgroup you're being grouped, so that in the breakfast time you can also connect with the other members of your group, right? We'll start with you, sir.
Happy morning. I am Vinay and Sanji. I am a practicing chartered accountant. I am based out of JP Nagar. I am a part of KR Market Group.
Happy morning. My name is Murali Krishna, partner in Murali and Smith. My office is in Jayanagar. I am part of Jayanagar subgroup.
Happy morning. My name is Praveen. I am working in Shekhar and Yatish Chartered Accountants, and I guess I have to be part of one of the group, not yet allocated. Yeah.
Good morning, I am Madhukeshwar Hegde. My partner at BVC & Co. Malleshwaram. I am in Malleshwaram group. Thank you.
Hi, good morning everyone. I am Venkatesh, practicing chartered accountant, and I am assigned to the care market group.
Hi. Hello. Good morning. I am Venkatesh Prabhu, practicing chartered accountant in Nagarbavi, and I am assigned to Vijayanagar group.
Good morning, everyone. My name is Niranjan. I hope I assigned to Jayanagar group. My office is in JP Nagar second phase.
Good morning, all. I am Nagappa B. Nesur, practicing in Rajajinagar. I have been assigned to Vijayanagar group. Thank you.
Good morning. I am Kotresh, a practicing chartered accountant. I have been assigned to Kumar Park group.
Good morning, everyone. I'm Roshan Mansoor. We are a practicing CA firm out of Bangalore. We are 30+ member team, and I hope I'm assigned to a Jayanagar group. Thank you.
Good morning, everyone. My name is Ilangovan, practicing chartered accountant. Our office is based in Indiranagar, so I am assigned to Race Course Road group. Thank you.
Hello, good morning. My name is Rakesh, a practicing chartered accountant. I am a part of Chamrajpet group.
Good morning, everybody. This is CA Deepak Jain. I'm coming from Shimoga. I'm actually a deputy convener of Shimoga CP chapter. Also, indirect tax committee member of KSCA. I'm very happy to be here. I'm in an online group of KSCA. Thank you.
Good morning, everybody. This is Vijay. I'm a partner at Malya & Malya Chartered Accountants. I've been part of Kumara Park Group. Thank you.
Very good morning, everyone. This is Tippeswamy, Chartered Accountant from Basamgudi, part of Kumara Park.
Happy morning, everyone. Myself, Ham Sundar, working in Manoj Chaudhary and Associates. I was part of Vijayanagar group.
Hi all, I am Arun, working in Manoj and Associates. I am part of Vijayanagar group.
Happy morning everyone. I am Vinay Kumar, working in Shekhar and Nitish. I am part of Care Market Group.
Good morning, everyone. Myself, Venkatesh Shanai, practicing in Yelahanka, and I am part of Malleshwaram group.
Good morning, everyone. I am Hari Prasad, practicing chartered accountant at Jayanagar. I am part of Jayanagar group.
Good morning, everyone. I am Shiva Panesur. I am practicing in Bagalkot district, Dur Taluka, and I am part of this virtual session.
Good morning, everyone. This is Ashish here. I am working with JCSS, yet to be assigned any group yet.
Hello everyone, my name is Bhushan Bhatt. I am a practicing chartered accountant from Hubli. I am assigned to a Hubli group, online group.
Morning everyone, I am Praveen, practicing in Karnataka. I am assigned to Jayanagar group.
Good morning, I am Akshay Krishna. I am practicing in Mysore. I am in online group.
Happy morning, everyone. I'm Ashish, partner at AAC and Associates, in practice for almost 8 years now. I'm assigned to Racecourse Group.
Hello, I'm Rohit here. I'm a partner of Manish and Rohit. I'm yet to be assigned a group.
Good morning, everyone. I'm Poonam Jain. I'm practicing at Rajajinagar. I have been assigned to Malleshwaram group.
Good morning, all of you. I am Sujata. I am practicing from JP Nagar. I am assigned to Jayanagar group.
Good morning, everybody. I'm Babita. My office is in Jayanagar and I'm part of Jayanagar group.
Introducing yourselves, I now request C.A. Sunil Bhandari, the Joint Secretary, to give a memento to our C.A. Naveen Kariwal, sir. Thank you, sir.
Now we are starting with another session with Shri C.A. Narendra Kumar Jain present here. I'll ask our Secretary Shri Vijay Kumar Patel to welcome him. Welcome, sir. Thank you for accepting our invitation. C.A. Narendra Kumar Jain, advocate, is a commerce graduate and FCA. He is also a company secretary and holds bachelor degree in law. Narendra has experience over 18 years in advising clients and handling tax litigation in income tax, transfer pricing, corporate tax, international taxation, and GST. His academic distinctions include All India 5th rank in CS Inter, D.L. Mazumdar Silver Medal for secure highest marks in Advanced Company Law and Practice in CS Final, Taxman's Prize Award for securing highest marks in Direct and Indirect Taxation Law and Practice in CS Final, Mrs. Pankajan Rengachari SIRC Prize Award for securing highest marks in Advanced Company Law and Practice in CS Final. He has authored and co-authored following books. Authored book Analysis of Transfer Pricing Judgments, published by CCH in 2 editions. Co-authored book on Digital Commerce and Analysis of Taxation Aspects and Emerging Issues, published by IFA Bangalore Subchapter. Co-authored book Permanent Establishment Emerging Trends, published by CTC and Taxman. Co-authored book New Age Assessment Penalties and Appeals, published by KSCAA. He is a regular speaker at various conferences, workshops, study circle, NADT, etc. His teaching stints include teaching for CA students at CAPS on direct taxes, international taxation, transfer pricing from 2004 to 2018, and for CA final students at ICAI Bangalore branch. Narendra was convener of Bangalore subgroup of Chamber of Tax Consultants, Mumbai for 2019 to 2020 and treasurer of International Fiscal Association, Bangalore subchapter from 2018 to 2020. He is currently the Joint Secretary of Bengaluru ITAT Bar Association. We welcome you, sir, and over to you.
Good morning. I have to, because of a small injury, I will be taking the session sitting, so I hope that is fine. Right. I, first of all, quite few seniors in the here and a lot of youngsters also. So it's a good combination of experience and energy. And I should thank and congratulate KCA for planning this wonderful program, which is a blend of legal provisions and practical experience, and all the participants will also get to argue a moot court kind of situation in a real life situation. So that's a very fantastic program, and nice that KC has planned this. There is a requirement of such kind of a blend of legal, practical and legal programs. So the first session which has been allotted to me, so we'll try and to look at the legal provisions. So as we all know, income tax, we follow a hierarchical system of tax litigation in our country, where we have assessing officer at the bottom, who's a quasi-judicial authority, then you have Commissioner of Income Tax Appeals, then we have Income Tax Appellate Tribunal, and we have the High Court and Supreme Court, right? So there is a system of appeals that have to go through this particular mechanism, except in few cases where the appeals may directly come to tribunal. In most of the cases, it will flow from the CIT appeals order. And Income Tax Appellate Tribunal, being a very important body in terms of tax litigation, it is very important for us to understand how it functions, what are important provisions related to that. So first, this 2.5 hour session will focus on how the background of the tribunal, what are important aspects, that practical aspects also we should be aware of. Then we will go into legal provisions. Legal provisions are 252, 253, 254, 255. And there are Income Tax Appellate Tribunal rules, 1963. So don't confuse this with the Income Tax rules 1962. Wherever I am referring to rules, it will be Income Tax Appellate Tribunal rules, 1963. Given that the tribunal has rule-making power also, it can administer its own procedure by virtue of section 255(5). So therefore, under 255(5), the Income Tax Appellate Tribunal has made its own rules, which is the Income Tax Appellate Tribunal rules 1963. In 2017, they had proposed a draft rules, but it is not notified, so we have to go by 1963 rules. As in future, these rules may get modified. There was a proposal for 5 years, it's in cold storage. Okay. So if you see the tribunal, I hope all have the material. It's a material which I have given, tried to make a material covering most important legal provisions, which you can also refer with case laws. There are a lot of case law references. I will highlight some of the important case laws. All of you should go and read those case laws. If you really want to think about a tribunal practice, all of you should go and read those case laws. As we proceed in the presentation, I will highlight those case laws. Their citations are there in the paper. But you can go and read those case laws, which really are the foundation of income tax appellate practice. Now it is, all of us know that Income Tax Appellate Tribunal is called as mother of all tribunals. Why it is called mother of all tribunals? Yes? It is oldest, 75 years, it is set up in 1941, more than 80 years old. That was the first tribunal which was formed. It was formed in 1922 Act, Section 5A of 1922 Act. It has the highest number of judges, 126 sanction strength. 63 benches, 126 sanction strength, 26 locations. No other tribunal has that wide area of coverage. If you see other tribunals, they will have very few benches. And Income Tax Tribunal is one of the most efficiently working tribunal. If you go to other tribunals, you will find that the cases will come after 4 or 5 years. There are no members many a time, but that is not the case with Income Tax Tribunal, at least till date. What happens in future, none of us know, but it is one of the most efficiently functioning tribunal in it. This is why it is called as mother of all tribunals. Now, why tribunals came in and why tribunals were proposed? If you see this, compare this with other courts like civil court, commercial courts or criminal courts, they have their issues with that, because if you see civil courts, it will take so many years for a case to get resolved. That is not the case with, at least with the income tax appellate tribunal, where you will get judgment in 2 to 3 years, and nowadays only in 1 year. Because CIT appeals is not disposing the matters, you have a very low pendency at tribunal, and your appeals may come up for hearing after filing in 2 to 3 months. Right? So it's a very fast disposal. One of the motto, what is the motto of the tribunal? That old one was easy and sulabh and satvar nyay. But in 2016 they modified it to nispaksh, impartial, fair, and easy and speedy justice. That is the logo of the tribunal. And it fits it also properly, because that is how it has been. If you see other courts, the disposals will be very slow, but this has been very clear. Now, tribunals were formed at that point of time. Why tribunals were thought about is the civil courts, criminal courts have to go strictly by the evidence and rules. Tribunal is not full court, but it is a kind of a court. It has a trappings of court, but it is not a full court. So it administers its own procedure. So there is a flexibility in that, one. Second, if you see tribunal, it hears income tax appellate matters only, income tax related matters. Income tax appellate tribunal hears income tax matters. So judges are well versed with the subject. If you go to High Court, the judge hearing a tax matter will also be hearing, say, education matter, land matters or something else. He may be hearing other civil matters or anything else. Whereas when it comes to income tax appellate tribunal, the judges are well versed with the subject. The people who are appointed also, earlier it was 10 years of experience. Now the government has been trying to modify this, and a lot of issues are going with that also. And 2017 Finance Act, section 184 of the Finance Act, they tried to change the way tribunal functions. If you, all of us will be knowing that in the Act it is provided 10 years of experience of a CA can be appointed as a tribunal. 10 years of an advocate experience can be appointed a tribunal. All these years, the president of a tribunal would be from the existing members only. Okay? What happens is when it is a member who is from the existing group only, suppose you have 100 judges and out of that one person becomes a president, he knows those people, he knows the functioning of each of the tribunal. Somewhere government thought that they should bring in an outside person. So they had proposed, and there is an amendment in the Act also, that in High Court judge, sitting High Court judge who has a more than 7 years of experience of an High Court judge can be made as a president to tribunal. That is where Gujarat High Court Justice P.P. Bhatt was appointed as a president. He retired, and now we have accountant member Pannu as the president. So then in 2017, they made this amendment in 184 Finance Act to provide that they will administer and change the rules and regulations against not just income tax tribunal, around 17 tribunals. Okay, so one of the changes which was there, it was challenged in Madras Bar Association case, then 2019 rules were framed, 2020 rules were framed, 2021 rules were framed, because of which there has now created a delay in appointment and vacancies are there. One of the things which is really bad in those rules is for a CA to become a member, the condition is 25 years of experience. Now, which CA after 25 years of settling and establishing his practice will go to tribunal, right? For advocate, also they had proposed 25 years. They fought it, and for them it was made 10 years. For CA also now the writ petitions are filed, and possibly we may change in the rules and all that. So those things are going on. Apart from that, there was another provision in those in these rules is currently they want to earlier, once the member has been appointed as in the tribunal, there are two kinds of members, accountant member and judicial member. So once a member is appointed in the tribunal, he is there till retirement, till the age of retirement. But now they want to appoint for a period of 3 years and then reappoint him. So this gives a sort of control to the government over the members, which is against the independence of tribunal. So this is one of the issues which is there. But Supreme Court said that at least 5 years should be done. They are again going on with the 3 years. Hopefully these issues will be resolved. Okay. So as we all know, there are two kinds of members, accountant member and judicial members, right? Each bench has these two members. Accountant member comes from the accounting background, CA, or from the revenue services. Commissioner can be appointed as an accountant member. And judicial member will be, say, person who is been an advocate in the tax field or some judicial officer can be appointed as a judicial member. Bench consists of these two in the tribunal, and on occasions there can be special bench. What are special bench? Minimum 3. It can go up to 5 also. So the constitution of bench, as you see on the first page, there are authorities: president, vice president, members, judicial accountant, registrar, deputy registrar, assistant registrar. So out of this, the president is like the first senior, the person who is appointed by government as president, and he controls the entire administration of the tribunal. Administration in the sense constitution of benches, transfer of members, allocation of cases, constitution of special benches. Those aspects are all covered by the president. Okay? Some aspects are delegated to vice president. We have 10 zones of tribunal. In India, entire India is divided into 10 zones. Like the Bangalore bench is a zone. So Bangalore bench and Cochin are one zone. So the vice president in Bangalore controls the administration of Bangalore bench and the Cochin bench. Administration in the sense, who will sit on the bench, what should be the combination of bench, what kind of cases can be posted, aggregation of cases, segregation of cases, all that is controlled by the vice president in there. There are 10 vice presidents, 10 zones. Each zone is headed by a vice president, and he controls the president. So some powers have been delegated from president to vice president, which are the regular administrative powers like constitution of benches, transfer of cases, etc. within the zone, all that. But otherwise, tribunal, the president enforces or controls most of the powers, like constitution of a special bench. Then that is controlled by the president. Transfer of members from one bench to other bench is controlled by the president of the tribunal. So this is how it works. And then there is also called as SMC. What is SMC? Single member cases. So if the total income is less than 50 lakhs, the president or vice president may decide that that case can be handled by a SMC, single member cases. Not all members can sit on SMC, only government notified senior members can sit on the SMC. We will see the provisions as we go further. But these are 3 kinds of benches we will have. We will have one more concept of third member we will see as we go forward. That normal bench, SMC and special bench. Special bench is 3, sometimes 5. It's a very important issue. It can go to a 5-member bench. The Bangalore special bench was Aztec Software's case was a 5-member bench. It's a classic case where and 5-member was there. There's also Mumbai Tribunal of Sumitomo's case was a 5-member bench. And very important issues may be heard by a larger bench. We all know the concept of constitutional benches in Supreme Court, right? Large number of judges sit, 7, 9, 11, 13 sit for deciding in important matters of this thing. Similarly, that is the case with the tribunal. If the circumstances are such, they may constitute that it's a circumstance, the issue or question of law is such that they want a larger bench, they may constitute a larger bench. Then there is, okay, one more thing you have to understand is, anyway we will discuss as we go further, is the territorial jurisdiction of each bench and zone, which you have to keep it in mind. For example, the Bangalore bench, right? What kind of cases or from which territory the cases can be filed to Bangalore bench is also notified. So each bench, in Bangalore we have, in Karnataka we have 1 bench. But there are states where we have 5 to 6 benches, right? In Karnataka also, if you have a case from Belgaum, Karwar, Mangalore, where will it go? It will go to Goa bench, Panjim, not to come to Karnataka bench or Bangalore bench. So you have to be very careful which zone or which bench is having a jurisdiction of it. When we go further, we will discuss it further, but that's something which we need to keep it in mind. The language of tribunal is English. In certain states, mostly the Hindi speaking states, by virtue of rule 5, 5A, 5B of the income tax appellate rule, Hindi has been notified. So they can argue the matter in Hindi, give the papers in Hindi, orders also can pass in Hindi, but along with an English copy is the mandatory. For Karnataka, we have to follow the English as a language. But some states, Hindi speaking states like UP, MP, there they have permitted the Hindi also as an alternate language for the tribunal. Now, when we file an appeal to tribunal, one more thing we have to keep it in mind is the appeal. Is it a legal right available with everyone, or is it a statutory right? It is a statutory right which is created by statute. There is no inherent right of an appeal. If law does not provide, you cannot file an appeal. If law does not provide, you cannot file an appeal. It is unlike suit. Suit, you can file any frivolous suit, defamation suit against anyone, this suit, that suit, whatever you can file. But appeal is not that way. Appeal has to be a statutory right provided in the statute. So if a statute doesn't provide a right, you have no right to appeal. You will see many such cases before CIT appeals also, before the Income Tax Appellate Tribunal also. There might be an order, but there is no right to appeal. For example, a lower deduction certificate rejected by an officer. Can you go into appeal? You have to go to writ because there is no mechanism to file CIT appeals for that or Income Tax Appellate Tribunal to that. Either you go to a writ or you file a 264 application. And 264 order, can you file an appeal? No, because it is not an appealable order. So you need to be aware of these things, that what is an appealable order, which is what we call as right to appeal. And this has three ingredients: locus standi, appealable order, and limitation and jurisdiction. So these three things which are there on page 3, these have to be taken care for every person or every appeal. So keep it in mind, appeal is a statutory right. It is not an inherent right or fundamental right or something. It is born out of statutory provision provided in the statute. If the statutory provision is not there, there is no right to appeal. So there has to be a statutory provision for you to fight an appeal against this. Okay? The right to appeal in case of income tax appeal to the Income Tax Appellate Tribunal is born, or the right gets vested in the assessee when the CIT appeals or the AO passes the order. CIT appeals in most of the cases, in some cases final assessment order by the assessing officer. So that is the time when the right to appeal vests. For example, if a draft assessment order is passed, there is no right to appeal. You have to see what is the order. A show cause notice is issued, there is no right to appeal. So it vests when the assessing officer passes an order in case of final assessment order like 144C, 144BA. In cases of CIT appeals, when the CIT appeals passes an order, that is the time when the right to appeal vests. Okay? For the department to file an appeal to tribunal, also the right to appeal vests when the CIT appeals passes an order. Till then, there is no right to appeal to go to the tribunal. Right? Then the maintainability of appeal. That's the first point that the court will look into, whether the appeal itself is maintainable. You filed an appeal, you filed the papers, but appeal papers, whether the appeal is maintainable. Three ingredients: locus standi, limitation, territorial jurisdiction. Locus standi means who can file the appeal. What is your standing? What is your place of standing? Right? When we compare this, when we look at 253, there should be a person who is aggrieved by the order. Assessee should be aggrieved by the order. Right? If your assessing officer or CIT appeals gives you complete relief, no doubt no one will file appeal, but then that is not, there is no locus standi to file an appeal. One classic case of locus standi in the income tax context was Myco's case. Myco's case, the citation is 292 ITR 657, not given in the paper, but 292 ITR 657, for you to understand what is locus standi. Now, the assessing officer in that case passed an TDS order, 201 order on Myco. Myco was the company and there were certain employees. So they said that you have not deducted proper TDS under section 192. And he said, raised a demand under 201 saying that this is the TDS of the employees which you have not deducted and remitted. Now the question is, who has a right to appeal, company or employees? The company may ultimately recover the TDS from the employees. The employees may ultimately get the, maybe saddled with the additional TDS. Okay. Now the Myco Employees Association filed a writ petition to the Karnataka High Court. The appeal was pending before the CIT appeals. Company filed the appeal to the CIT appeals. Okay. These employee association formed it was an association which filed a writ petition to the Karnataka High Court saying that we are also aggrieved and our writ petition should be considered against this 201 order. The High Court said, no, look, the appeal is pending before the CIT appeals. I will direct the CIT appeals to at least give you an opportunity of hearing. The CIT appeals give an opportunity of hearing, and as usual he dismissed the appeal. Now who should have filed appeal to the tribunal? Company or employee association? The company is ultimately recovering from the employees. The association filed an appeal to tribunal. The company did not file. Company said, company was not bothered, probably it was recovering from the employees, and maybe it is not bothered, or whatever reason, company did not file. The employee association's appeal to the tribunal was dismissed by the tribunal that you don't have any locus standi, order is against the company and company should have filed the appeal. This matter went to the High Court and High Court confirmed the view of the tribunal that appeal should have been by the company and not by the employee. And no doubt indirectly the employees might have suffered, but against whom the order has been passed? The order has been passed by the company. So if a firm has an tax liability, partner cannot go and file appeal. So locus standi, who's against who, what is the place of standing of that person has to be kept in mind while you are filing the appeal. So that is one important aspect we have to keep it in mind. Limitation period. What is the limitation period? We have 60 days from the date of receipt of order. Some aspects of this we will discuss, but so limitation period is another thing. Once you file an appeal delayed, so that goes to the maintainability of the appeal. If you are filing the appeal late, then naturally the tribunal will, the registrar will issue a notice saying, a registrar, assistant registrar, whoever, why have you filed the appeal delayed? Okay, we'll come to condonation, but this is another ingredient of maintainability of appeal. So appeal will be maintainable, locus standi, then limitation period. The appeal should be filed in time, right? Third ingredient is jurisdiction. Jurisdiction in terms of the jurisdiction of tribunal to entertain the appeal. As I gave an example of Belgaum. So if a Belgaum person files an appeal in Bangalore, the Bangalore bench will say, we don't have any jurisdiction, so we will reject the appeal or dismiss the appeal. Right? So you have to be very careful. In certain cases, there could be the zone-wise classification issues where you will have to be careful that where you have to file the appeal and what is the territorials, what is the jurisdiction of the tribunal. Now, when we look at 253, 253.1, 253.2, 253.1 for the appeal of the assessee, 253.2 for the appeal of the revenue. So that is incorporates the ingredient of the locus standi. It says that the assessee should have aggrieved by the order, then only an appeal can be filed under 253. If CIT appeals allows all your grounds of appeal, can you still file an appeal to tribunal? Are you aggrieved by the order? You are not aggrieved by the order. So in those cases, naturally, there is no, no one would file also, but the legal provision what we need to understand is the party should have suffered harm, suffered some grievance by an order for it to be an appealable to the tribunal. So there should be an aggrieved party, both for the assessee as well as for the revenue. The condition in 253.1, 253.2 remains same. Next concept we need to understand is cross objection. What is cross objection? And when will this come into picture? 253 subsection 4. 253 subsection 4 on page 4. So what happens to cross objection, or what is cross objection? Anyone has filed cross objection? Okay. Now suppose you have filed an appeal to CIT appeals. Suppose there are two issues. Say 147 legal issue, we are challenging saying that the 147 reopening does not satisfy the test of section 147, so you cannot reopen the case.